I would say prime virtue was that he was kind and that he showed up for people. He showed up for everyone, and he didn't care if you were a waiter or a busboy or a movie star. And I hated that.
Hi, besties. It is Katie from Without a Crystal Ball. Welcome back to my channel. It's not every day that I can say something with confidence and without being accused of slander. Although most people, even if you speak truth or report truth, if they don't like it, they can call it defamation or slander. That's what Meta told Stephanie Jones about her motion to compel information about the users' identities of the Stephanie Jones Lies Facebook page, in that she would have to prove that anything in there is actual defamation. And it's not. It's First Amended protected speech. Now, other people that are known to be habitual pathological liars, painting a narrative and pushing a public agenda, Blake and Brian Reynolds. And that agenda was pushed in court yesterday. And if you recall, I said the reign of terror is over, and it is. Now, some of you said my video was clickbait. I would say not, because I would say for every content creator that has been dealing with this case, there has been this constant looming threat to many of us. I have received cease and desists. Others have received subpoenas. Others have been brought into it and slandered repeatedly and not subpoenaed, like Shasti. And when a judge finally steps in and says, listen, all subpoena documents must be produced by July 25th, means she can't subpoena anyone anymore. So creators like me don't have to worry that we're going to get dragged in. And if Perez hasn't received his subpoena, he's probably not going to have to do anything about it. And if documents have to be produced in the next 2 weeks, Candace and Andy might be off the hook. It's good news. It means she can't and they can't continue to interfere with independent journalists and content creators. Now, in their motion, when they were doing their leave to file, they made this over the top accusation against Brian Friedman, and they attached a 300-page filing by an attorney representing a former assistant that worked for Vin Diesel for 9 days back in 2010. And she is suing him for SA under under a new law that Gavin Newsom passed, which allowed people that are victims of SA to go back. Like, he extended the statute of limitations and it went back to 2009. So if you had a claim at 2009 or before, you could bring a claim against someone. As an employee, though, he didn't change the requirements for the CRD. And so she had filed this lawsuit basically claiming workplace discrimination and negligence and all of that on the job. And all of those claims were thrown out because she didn't file a complaint with the CRD in time and they were time barred. So what's left are actual just claims of SA and other counts. But all of the workplace stuff is gone. And Vin Diesel has denied these allegations along with his manager/sister, who claims that he was never in California during the period of time that this woman claims this happened. I'm not getting into the middle of that case because it really has nothing to do with this here, except for that filing. And in that filing, they sent a very, I would say, misleading, very misleading representation about what happened in the court with Brian Friedman. They attached this 300 pages, and it's a 300-page motion for motion to compel Vin Diesel, and it's also to award sanctions. And it was an ex parte, and they had already filed a motion to compel already. So it was like on addition of the motion to compel. And the same exact day that they filed that, Brian's firm actually responded asking the court to deny the request and providing all kinds of reasons for why. Okay. So they filed it the same exact day as the 300 pages. In fact, in the introductory paragraph of their response, which, by the way, Blake's attorneys did not include, it says it's now plainly evident that absent court intervention, plaintiff will ensure a trial in this action takes place in the sewer. Plaintiff's improper application is offensive to the dignity of this court. The application was designed for no purpose other than to demean and disparage defendant's counsel with actionably false accusations. It should promptly be denied on multiple grounds. So they denied it. They said it's actionably false accusations. Actionably, meaning that it's an actionable statement that they could take action on. Their argument was that part of the reason they filed the ex parte application this way was because they needed to be able to show immediate danger or harm, and that they had provided no evidence supporting the existence of irreparable harm or immediate danger if it was not granted. Their argument was that this was filed in response to their move for a protective order based upon discovery deadlines and seeking changes in the when the case would be tried. And they denied everything, right? They said, absolutely, this did not happen. This is not what happened. And this is actually an inappropriate motion to bring. You can't ask for this on an ex parte motion. You can't ask for an ex parte motion to compel. And you're only doing this because we sought a protective order. So they're calling it retaliatory and without merit. Okay. So if you present one side, you should present the other. And I don't know what happened. I really don't. But whatever did happen didn't move the judge in this case, okay? Because according to a notice that was filed on July 3rd, which Blake's and Ryan's attorneys had access to when they filed those 300 pages, by the way, there was already an agreement and order from the court about that actionable sanctions and violence that happened at the deposition. And do you know what happened in that hearing? The judge did not deem it credible. And in fact, they got no money for it. The conference came down to the parties reaching an agreement and resolving their disputes. Interesting. They resolved their dispute. If something really violent happened, I'm assuming nothing, no, there wouldn't have been a dispute that needed to be resolved, right? If he was really violent, you would have thought he would have gone to, I don't know, police. But the order from the court says on August 18th, trial date is vacated and continued to February 2nd, 2026. Final status conference, August 8th, is vacated and continued to January 23rd. All dates previously established per either of the Code of Civil Procedure and the Los Angeles Superior Court rules by virtue of the previous trial date are also vacated and continued so as to correspond to the new trial date, including discovery cutoff dates. They shall complete a form of alternative dispute resolution by November 7th, meaning they have to at least try mediation before they go to trial. They have to have a status regarding the ADR on or before the 7th. It says plaintiff's August 11th, 2025 motion to compel deposition is taken off the calendar. Oh, huh. Why? Why is that? Defendant's December 11th, 2025 motion for a protective order is taken off the calendar. They actually agreed to a date for the deposition of Diesel, which will be on September 3rd at the office of the defendant's counsel. And in this case, they agreed they would do it at Vin Diesel's attorney's offices and not exceeding more than 7 hours. The plaintiffs wanted to do unlimited number of hours over 2 days, which isn't allowed. And then a non-party subpoena or non-party deposition would be done on the 12th. They should meet and confer on the rescheduling of other non-parties, and plaintiff will allow for the production of records sought by defendants from non-party Walt Disney Company pursuant to the subpoena, and they will provide all copies to the defendant. So they took it off the calendar. They took it off the calendar which means it was denied. In fact, minute orders from the hearing that were on July 1st, it says the court and counsel confer regarding the matters on calendar this date and this discovery issues. Counsel argues on the matters. After oral argument, the court rules as follows. The ex parte to compel the deposition is denied. So they denied that entire 300-page document. They denied it. No sanctions, no motion to compel, everything in there completely irrelevant. But that's not what Lively's attorneys told the court. Instead, they made it seem like this was a present issue that was still unresolved before the court. In that hearing, they orally stipulated to the depositions. They agreed on the date when Vin would go to his, and the court deemed the issue resolved. And interestingly, there's absolutely nothing in here that says counsel reprimanded for improper conduct before the court, or unprofessional note reprimand for unprofessional conduct by the defendant's attorneys. Nothing. Absolutely nothing. In fact, they got what they wanted. Brian did. He wanted Vin Diesel to be deposed at his office due to security issues, much like Blake is asking for in her case. And if they're amendable, and if a judge is amendable, they can bring a motion to the court for intervention and ask that the deposition be held there if they can't agree. The thing that bothers me about this specific case is that, and it happens a lot, in my opinion, when you are covering and dealing with narcissistic litigants, is one side has a client that's being slandered, defamed, and whatever, and they're not the narcissist, right? I don't believe that Justin is a narcissist. I don't. Um, I feel like he would be much, like the most narcissistic people are the ones that become ultimately the most famous because they're the most willing to kind of stomp on everyone to get to the top. And that's not always true, but that's often true in Hollywood. And I just don't see him like that. He's got this like puppy dog look where he's interested in making feel good stuff, that feel good content that has a message. And he's not necessarily interested in all of these blockbusters, although he was going to make Pac-Man, the movie Pac-Man. And now that's not happening, which maybe that's another reason why Ryan went after him, or that, his ex-wife did a film with Justin, and now Scarlett is named the most, she surpassed other actors as the most powerful in Hollywood in terms of the amount of money she gets and makes and commands per film. His ex-wife is more powerful than him. I'm sure he's seething. And Scarlett did note in an interview that she thought it was interesting timing for Ryan Reynolds to go after Baldoni. So there's that. But what I find interesting here is that the attorneys that they've hired are from aggressive law firms. And Gottlieb historically has gone for and repped underdogs fighting the establishment. Like he was the attorney for the two women that Rudy Giuliani was accused of defaming and claiming that they were like doing election tampering when they weren't. And they won a huge judgment against Giuliani, and he had to go bankrupt. And that was a case of like they repped the underdog because Giuliani was more powerful. But this case is like the flip. It's like now they're repping the more powerful ones going after, like, it's like reverse Uno. So it's like now they're repping Giuliani and they are seemingly attacking the two election workers. And it just seems like so diametrically opposed, which had me thinking that maybe this is why Merrill, the attorney that left his office, has taken a lesser role in the case. She doesn't file anything anymore, really. She was very prominent in the very beginning, and she has over time become less and less involved in this case. And the case is now primarily being directed by Kristen Bender, who works at Wilkie, who's a crisis attorney. Kristen Bender is doing all of the negotiation behind the scenes, and her specialty is crisis litigation, not sexual harassment litigation, crisis litigation. And Wilkie and Manat are known to be very ruthless. They have huge, powerful, like firms that have billions of dollars, lots of resources, and they can, if they want to, bury their opponents if it's a smaller firm because they have so many more resources. And so you have to consider the fact that Justin's also going up against not only Blake, but these powerful attorneys and very well known and very well established law firms. And he's still coming out looking oftentimes better than Blake. And while Brian Friedman is known to be a bit of an attack dog in the media, and he does generally like to litigate in the press in that, defending and advocating for his clients. He also has a very seasoned team behind him and at his law firm that he's using, like Ellen Garofalo and Jason Sunshine. And he also is relying on Mitchell Schuster and Kevin Fritz and that law firm in New York. And it's interesting in that Mitchell Schuster, if you know anything about him, he is very well known for representing huge celebrity athletes in New York, like football players and baseball players, like huge celebrity athletes. He's not at all immune or ignorant to high profile cases. And his office would be as well equipped to manage the security level needed for Blake to be comfortable in order to serve a deposition. If they wanted to be amendable, and give in to Blake, they could. But sometimes when other attorneys do things like what they did yesterday, where they seemingly just went to the court to smear Brian and ignoring the fact that this case, the sanctions were denied. He wasn't held liable for unprofessional conduct. It was an allegation that Brian denied and the court didn't take seriously. If the court didn't take seriously the allegation and they denied the ex parte motion to compel, you can't then say this is proof that it happened. It's an allegation, and that is all it is. And they ultimately resolved the dispute. Blake's team is desperate, though. That's how I view it. And I think that was just added to smear Brian to make him look dangerous. And to me, this kind of behavior by these lawyers it disgusts me. Lawyers are being paid to smear Baldoni and all of his associates for Blake and Ryan, even presenting them misleading information to paint Brian, as dangerous, which wasn't deemed credible by the court. And again, I don't know what happened. I just know that the judge said that it was denied. Doesn't mean something didn't happen, but it wasn't serious enough that there was any sanctions against him. Facts. So sometimes, long story short, a lot of you have asked me, why do they file so many motions? Are they getting paid by the number of documents? No, 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 no. They're getting paid by the hour, friends. And as they're getting paid by the hour, they're going to bill as many hours as possible. And the more hours they bill, the more money they make. And sometimes when you have clients that don't care and won't listen, you just file what they ask you to file. Some people have said, "Well, no, Ryan and Blake have no say in what is filed." That's not true. They have to have permission to file anything in court. So if they're going to file something, you have to be like given a heads up. Oftentimes, if they're going to file a motion or a complaint, you're going to be proofreading it because ultimately they're there to represent you. They're not just there for the sake of like they can't just put anything on a document. They have to represent the truth of what you know. So they're working for Blake and Ryan. So they're doing what Blake and Ryan want, even if it's unscrupulous, even if it means smearing them in court. But Kristen, who is a PR, apparently a crisis attorney, she's apparently very good at that. But again, the judge ignored it, and they have been now busted lying. So, what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.